Hello everyone, welcome back to Kalam IAS Academy, and we are looking at the current ed series, and today we will be dealing with the polity current affairs. This will be our class 1. In the next session we will be doing the class 2, right, and if required we will be doing more classes, but most importantly 2 classes will be there. In the polity current affairs we will be looking up the current issues which has been there in last 1.5 years, right, from January 2023, right. And when you are talking about the polity current affairs, as you know that in the UPSC exam, the UPSC Prelims, the UPSC asks questions more of the basic facts, right. Conceptual clarity is very much required, right. If ordinance is news, then you must know how ordinance is being issued by the president or the governor. So by looking at the news, we will be judging what can be the possible questions from here, and we will be dealing with that topic, right. So that will be our approach in this class. Let's start our polity current affairs of last 15 months. Okay. The basic structure doctrine, this was in news because the basic structure doctrine को आए हुए around 50 years हो चुके हैं. 24 April 1973. On this day, the judgment for the Keswanand Bharati case came, and from there the basic structure doctrine got established in our country, and the basic feature of the constitution came into the existence, right. That's why this was in news. When we are talking about the basic structure doctrine, so whether it is written inside the Constitution of India, it is not written inside the Constitution of India. Time to time, again and again, judiciary decides what is the basic feature of the Constitution of India, right. Just one second. So it is not defined in the Constitution of India, right. Can it be amended? As the Supreme Court has said that these are the basic feature of the Constitution of India, and as per the basic structure doctrine, these cannot be amended. According to Article 368 of the Constitution of India, the Parliament has the power to amend the Constitution of India, but the basic feature of the Constitution of India cannot be amended. Whether the Supreme Court has provided an exhaustive list for the basic structure doctrine, whether they have provided the exhaustive list for the basic features, they have not provided exhaustive list. Time and again such features comes up, right. For example, this right now there are several basic features of the Constitution. For example, supremacy of the Constitution of India, rule of law, democratic principles, parliamentary form of the government, federal features, secular features, right. So these are all the basic features of the Constitution of India. No matter how much majority a party has who is ruling the government and who is having, no matter, even if a party has 2/3 of majority, then also these features of the Constitution cannot be amended, right. I hope you have understood this. Another thing which was in news was abrogation of Article 370 of the Constitution of India, right. The Supreme Court verdict upholding the abrogation of Article 370. So it was in question. It was in question in the Supreme Court that whether the abrogation of the Article 370, whether it is constitutional or not. So what Supreme Court has to say? The Supreme Court has said that it is completely constitutional in nature. Article 370 was actually a temporary provisions, and more temporary provisions was Article 35A of the Constitution of India. So abrogation of these things does not violate the Constitution of India, right. It is completely constitutional in nature. So the Supreme Court has recently upheld the abrogation of Article 370 of the Constitution of India. Supreme Court also recognized that the Article 370 was not permanent in nature, it was temporary arrangement. As you know that 370 was there because Jammu and Kashmir was added inside the country, right, and through the instrument of accession, and after that special provisions like the separate constitution for the Jammu and Kashmir province, and for implementing that provisions article 370 was there. Also article 35A was there inside the constitution of India, right. So with the abrogation of article 370 of the constitution, what is happening, all the provisions of the article 370 will not be implemented now, and the article 35A of the constitution of India has also been nullified. Various kinds of provisions were there for the people of the Jammu and Kashmir, right, under the article 35A, like no one can purchase land who is not from the Jammu and Kashmir, right. So such kinds of provisions was there. So it gave the Jammu and Kashmir legislature the power to define the permanent resident of the states. With the abrogation of article 370 of the Constitution of India, one act came, that is Jammu and Kashmir Reorganization Act 2019, and with this the state Jammu and Kashmir has now been bifurcated into two parts, that is Jammu and Kashmir and Ladakh. Both Jammu and Kashmir and Ladakh has been made the union territories, right. And with that only the Ladakh has become the largest constituency, means largest constituency in area wise, because Ladakh has only one seat in the Lok Sabha. So whole Ladakh has only one seat, and that is a large area. So area wise this Ladakh constituency is largest in our country. Right now the protest is going on, we will be coming to that topic further when the Ladakh issues comes. I hope you have understood this. Then the pardoning power of the president and the governor. The mercy petitions, how changes proposed to the Bharatiya Nagrik Suraksha Sanhita, right. So as you know that the name of IPC, CRPC, all these acts has now been changed, right. So with the change of names, several provisions has also been changed inside the act, right. Regarding the pardoning power of the president and the governor, some provisions which was established through the Supreme Court judgments, that has not been included in the Bharatiya Nagrik Suraksha Sanhita. For example, when the mercy petition was declined, means when the pardon was not given and death sentence has to be implemented, then there was a provisions by the Supreme Court that at least 14 days should be there. Means जब पता चल गया कि अब डेथ सेंटेंस मिलेगा ही मिलेगा, राइट, तो उस डेथ सेंटेंस को एग्जीक्यूशन करने में 14 डेज का टाइम एटलीस्ट उसके बीच में होना चाहिए, सो दैट द विक्टिम means not victim, so that the convict who is to get the capital punishment, right, so they should be ready mentally, right, they should be prepared to be hanged. So these provisions of 14 days has been eliminated in this Bharatiya Nagrik Suraksha Sanhita. Another thing is, as per the Supreme Court judgments, it was said that whatever the decision of president or the governor will be there, that will be subject to the judicial review, but that judicial review part has been removed under the Bharatiya Nagrik Suraksha Sanhita. Maybe later on, once again when the Supreme Court analyzes this Bharatiya Nagrik Suraksha Sanhita, then in that case they may once again bring up that judicial review part. So this was in news. What you have to learn for the prelims, you have to learn about the pardoning power of the president and the governor. So whether it is constitutional, yes, it is unconstitutional. Under Article 72 of the Constitution of India, there is pardoning power for the president of India, right, and तो पार्डनिंग पावर जो प्रेसिडेंट का होता है, सो दैट इज रिगार्डिंग इफ एनी पर्सन हैज breached any union law, and regarding that, that person must have got the death penalty, right? So the president can pardon the death sentence also, right? So president can pardon the death sentence, president can commute the death sentence, remission can also be there, right? डेथ सेंटेंस के केस में तो ऑलरेडी पार्डन होगा या कम्यूट होगा, है ना? देन अदर फॉर्म्स लाइक द रिमिशन, रेस्पाइट, रिप्राइव, these things can also be done by the president. More importantly, the president can also this pardon court martials. Court martials होता है किसके लिए? जो आर्मी, नेवी एंड एयर फोर्स के जो पर्सनल्स होते हैं उन लोगों को कोर्ट मार्शल दिया जाता है. सो उन सब के लिए ये किया जा रहा है, राइट? अगर उन लोगों को ये दिया जाता है सजा, तो फिर पार्डनिंग पावर जो है प्रेसिडेंट का वहां पे भी एप्लीकेबल होता है. मीन्स द प्रेसिडेंट कैन absorb the court martial also. Similarly, the governor article 161 of the Constitution of India, the governor has the pardoning power, right? और इस पार्डनिंग पावर के थ्रू गवर्नर भी क्या कर सकते हैं? पार्डन कर सकते हैं, कम्यूट कर सकते हैं, रेस्पाइट कर सकते हैं, रिप्राइव कर सकते हैं एंड रिमिशन कर सकते हैं, है ना? तो ये सब सारा कुछ गवर्नर कर सकता है, बट governor cannot pardon the death sentence, right? Governor cannot pardon the death sentence. Now the question arises whether the governor can commute the death sentence into the life imprisonment. Yes, that can be done, right? But it cannot pardon. Plus, governor has no role to play when court martial is applicable, right? तो इस केस में गवर्नर के पास कोई पावर नहीं होता है. तो ये दोनों डिफरेंस हमने देख लिया between the pardoning power of the president and the governor. That is, the president has the pardoning power even in case of the death sentence, whereas the governor does not have. President has the pardoning power even applicable even for the court martial, but governor does not have such power, right? So hope you have understood this. बिफोर वी गो फर्दर, थोड़ा सा डिफरेंसेस आता है पार्डनिंग पावर के बीच में, मीन्स पार्डन में, कम्यूट में एंड रेस्पाइट, रिमिशन, इस सब में क्या डिफरेंसेस है. सो लेट्स सी. सो पार्डन इट रिमूव्स बोथ सेंटेंसेस एज वेल एज द कन्विक्शन, मीन्स बाइज्जत बरी कर देना. ऐसा बिलीव ही होगा कि अगर पार्डन मिल गया तो ऐसे फील किया जाएगा जैसे उसने कि कोई क्राइम कमिट ही नहीं करी है, राइट? So that will be the person will be completely absorbs the pardon will completely absorbs the convict from all sentences, punishments and disqualification, right? Whereas commutation is changing the form of the punishment, एक फॉर्म से दूसरे फॉर्म में. फॉर एग्जांपल डेथ सेंटेंस से चेंज करके किसमें? लाइफ इम्प्रिजनमेंट में, राइट? सो बहुत हार्शर फॉर्म से लाइटर फॉर्म में कन्वर्ट कर दिया. So that is commutation. Remission will be reducing the period of the sentence without changing the character. What does this mean? For example, if any person has to get 7 years of rigorous imprisonment, so it can be reduced to 4 years of rigorous imprisonment. So please remember that there is no change in the character. सेंटेंस का कैरेक्टर चेंज नहीं होगा, बट इट्स टाइम पीरियड कैन बी रिड्यूस्ड. सो दैट विल बी रिमिशन. द रेस्पाइट it denotes the awarding the lesser sentence in place of one originally awarded due to some special acts, right? इस केस में भी lesser sentence होगा, but this is not for everyone. This is a space for only for certain kinds of people. For example, physically disabled, pregnant women, right? So such kinds of people, as they cannot serve means very rigorous punishment, right? Therefore lesser form of sentence will be provided to them on the humanitarian grounds. So that will be respite. And reprieve is, it implies a stay on the execution of the sentence, especially that of the death, for a temporary period. Means for temporary period the sentence will be on pause, it will not be implemented, right. इससे क्या फायदा होगा, इससे ये फायदा होगा कि टाइम मिल जाएगा. फॉर एग्जाम्पल जैसे पार्डन सबके लिए प्रेसिडेंट के पास अपील जाता है, गवर्नर के पास अपील जाता है, राइट. सो दिस इज वेरी कम्बरसम प्रोसेस, इट टेक्स मंथ्स. सो when reprieve is given, the convict will get the time to go to the president or the governor for seeking pardon or the commutation, right. So that is possible. Another thing which was in news was Rajya Sabha passes the Delhi Service Bill. One bill has been passed, that is the Government of National Capital Territory of Delhi Amendment Act 2023, right. What is there inside the bill, that we will be reading. लेकिन ये न्यूज में था, राइट. और आपको ये ध्यान में रखना है कि दिस बिल हैज बीन पास फ्रॉम द पार्लियामेंट, from the Lok Sabha, from the Rajya Sabha, and then President's assent. Then this bill has been passed, because Delhi is a union territory, though it has some legislative assembly, right, but all the powers they do not have. The legislative assembly do not have all the domains, right. So this Government of National Capital Territory of Delhi Amendment Act 2023 has been passed through the Parliament. What is there inside the Act? So in the Act actually there is provisions to make a National Capital Civil Services Authority. What this authority will be doing? This authority will be dealing with the transfer and posting of various civil servants who are working inside the Delhi, right. So like there is Chief Minister of Delhi, its members, the National Capital Civil Service Authority, it comprises of the Chief Minister of Delhi, the Principal Home Secretary of Delhi appointed by the Centre, and Chief Secretary of Delhi appointed by the Centre, right. So that is there. So these three persons will be there. As you know that these two persons are appointed by the Centre only, right, and Chief Minister of Delhi will also be there. Whatever this NCCSA will make recommendation, that recommendation will go to the Lieutenant Governor, and this recommendation will be regarding the transfer, posting, vigilance and other incidental matters regarding the civil services or regarding the civil servants who is working inside the Delhi. So NCSA will decide the matters by the majority, right. So that will be decided by the majority of the votes of the members present and voting, right. And as you can see, only 3 persons are there, out of which 2 persons are appointed by the centers. So there are high chances that whatever the Centre will be willing to have, that will be implemented through the NCCSA. Then primacy has been given to the Lieutenant Governor. There is a Lieutenant Governor who is acting as a advisor, who is acting as a correspondent of the President, right. He is acting as the agent for the central government. So the Lieutenant Governor can approve or return the recommendation of the NCSA for consideration. That can also be done, and whatever the decision of the Lieutenant Governor will be there, that will be final and binding, right. So that will be there. Certain matters must be submitted to the Lieutenant Governor for his or her opinion prior to the issue of any order. This includes the proposal affecting. So there are certain issues for which the matters must reach to the Lieutenant Governor. The Legislative Assembly of the Delhi or the Chief Minister of the Delhi cannot decide upon these matters. What are those matters? The peace and tranquility of the Delhi, the relation between Centre and the states or the other states, summoning, prorogation and the dissolution of the Delhi Assembly, matters on which Lieutenant Governor is to give an order in his sole discretion. So, all these provisions has been made. The next thing which was in news was preventive detention. Sorry. Preventive detention. Article 22 of the Constitution of India. It deals with the preventive detention, right. So, safeguards and the procedures on the India's preventive detention law. Misuse of the detention power renders need to stick to the procedure paramount. So, basically preventive detention was in news. So, what you have to understand for the prelims point of view, that is Article 22 of the Constitution of India. Article 22 of the Constitution of India, it deals with two types of laws. One is ordinary law, another is preventive detention laws, right. So, these two kinds of laws are there. There are two differences between this, and there is differences between the punitive detention and the preventive detention. Punitive detention is when the crime has already been committed, right. A person is convicted, then that person gets detained. So, that is punitive detention, and another is preventive detention. Preventive detention is when the police detain any person so that they do not commit any crime, so that they prevent that person from committing any crime, right. So, that provisions is there here. Preventive detention के अंदर Article 22 of the Constitution of India, it is a fundamental rights. So, Article 22 का 1 of the Constitution of India, it talks about the right to be informed about the reason for arrest. If any person is being arrested, he must be told why that person is being arrested. And these provisions, Article 22 1 to Article 22 का 3, these provisions is there for the ordinary law. Then from Article 22 4 from Article 22 7. So, this is for the preventive detention, right. Article 22 for the ordinary law, the person has the right to be informed about their arrest. Then the person has the right to be defended by the legal practitioner of his choice. The person can go to the legal practitioner, means they obviously as the person is detained, so they cannot go to the legal practitioners. So, some legal practitioners can be hired for that person, right, who will be presenting his case in front of the judge. So, that is possible. Then a right to be produced before the magistrate within 24 hours. If any person is being detained, then that person must be produced before the magistrate within the 24 hours, right. And in this 24 hours, travelling time is not included, that is excluded. Article 22 ka 3, it talks about the above rights does not apply to the prevailing detainee, right. So, these provisions has been there. Now, what about the preventive detention? So, these provisions are there for the ordinary law, right. For the preventive detention, Article 22 4 to Article 22 ka 7, subclause 7 tak, these provisions are there inside the Constitution of India. So, what is the difference between the detention under the ordinary law or under the preventive detention? If detention is under the ordinary law, the reason for the detention must be told, right. The reason for the detention must be told. But in case of preventive detention, in general scenario, the reasons will be told, but if it is against the public interest, right, then in that case the reasons, there is no need to mention the reason also. A person can be put into the preventive detention for 3 months, right. So that is there. Under the ordinary law, if a person is detained, that person must be produced before the magistrate within 24 hours. But if under the preventive detention, there is no such provisions of the 24 hours. Once a person has been detained, that person can be detained up to 3 months. And even if the detention is required after the 3 months, that is also possible, but for that the advisory board has to be set up. And if that advisory board says that yes, more detention is required of that particular person, because that particular person may commit some kind of crime, criminal activity, right. So that preventive detention can further be extended from the 3 months also. ठीक है. Then must be defended by the legal practitioner of his choice. ऑर्डिनरी लॉ के केस में हमने देखा कि कैसे ये लीगल प्रैक्टिशनर ऑफ हिज चॉइस हो सकता है, बट प्रिवेंटिव डिटेंशन में मस्ट बी गिवन अपॉर्चुनिटी टू मेक रिप्रेजेंटेशन अगेंस्ट द डिटेंशन ऑर्डर, सो दैट प्रोविजन इज देयर दैट some kinds of representation can be filed by the convict. Under the detention, under the ordinary law, if a person is in prison, then that person cannot take part in the election, right. That person cannot vote in the election. But if in case of preventive detention, as that person still have not committed the crime, right, it is preventive in nature, so that person will get the right to vote, and that person will be voting from the what, prison itself. Then under the detention, under the ordinary law, a law can be made by the parliament and the state legislature. Means ordinary law can be made by the parliament and the state legislature. And preventive detention, for the preventive detention also a law can be made for the parliament or the state legislature both. ठीक है. Sorry for my bad throat. Now another thing which is in news is rights of personality. बहुत बार आपने देखा होगा कि स्ट्रीट पे बहुत बड़े सुपर स्टार सबका, लाइक शाहरुख खान, लाइक अनिल कपूर, इन सब का जो है फोटो लगा रहता है. सैलून में आप देखोगे कि बहुत सारे हीरोइन का, बहुत सारे हीरो का जो है, एक्टर एक्ट्रेस का वो फोटो लगा रहता है, राइट. ऑब्वियसली उन सारे सैलून्स को, उन सारे स्ट्रीट्स के जो स्ट्रीट वेंडिंग जो हैं, जो स्टॉल्स लगे हैं, उन सबको इन सारे सेलिब्रिटी ने नहीं प्रमोट किया है ना. तो अगर वो चाहें तो इस सबको बंद करवा सकते हैं, बिकॉज दे हैव द राइट टू ऑफ पर्सनैलिटी, है ना. और यही चीज वाज इन द न्यूज. द दिल्ली हाई कोर्ट restrains the misuse of the personality attributes of the actor Anil Kapoor, right. What is this rights of personality? So rights of a person to protect his or her personality under the right to privacy or property. So we have the right to privacy, we have the right to property, right. So under this a person has rights of personality, means under article 21 of the Constitution of India itself, the person will get the rights of personality. और ये इस राइट्स में क्या क्या चीज प्रोटेक्टेड होगा, प्रोटेक्टेड हो, जैसे नेम, कोई नेम नहीं यूज कर सकता इनका, वॉइस नहीं यूज कर सकता, सिग्नेचर नहीं यूज कर सकता, राइट. इमेज और एनी अदर फीचर्स नहीं यूज कर सकते, which can be easily identified as the maker of the personalities, right. जैसे बहुत बार आप देखोगे कि एड्स बनते हैं और उसमें अमिताभ बच्चन का मीन्स उनके आवाज में एड्स बन जाता है, राइट. एंड ऑब्वियसली दैट पर्सन इज नॉट अमिताभ बच्चन. अमिताभ बच्चन जो है वो प्रमोट नहीं किए हुए थे, राइट. सो दे हैव द राइट ऑफ पर्सनैलिटी, और अगर वो चाहें तो वो आर्टिकल 21 का यूज करते इन सब के अगेंस्ट खड़ा हो सकते हैं. एंड दिस इज व्हाट अनिल कपूर हैज डन. So though it is not explicitly mentioned in the any statute, means article 21 में right, it is not a right to personality, it is right to life or personal liberty, and under that only right to personality comes. It also includes the right to publicity, means right to keep one's image and likeness from being commercially exploited without permission. तो किसी भी सेलिब्रिटी के परमिशन के विदाउट उनका नाम, उनका इमेज, उनका सिग्नेचर, उनका वॉइस, ये सब चीज यूज नहीं किया जा सकता है, राइट, फॉर द कॉमर्शियल पर्पस, राइट. कोई एड बनाने के लिए, कोई एडवर्टाइजमेंट बनाने के लिए, तो इस सब चीज के लिए यूज नहीं किया जा सकता है. सो दिस इज व्हाट राइट टू पर्सनैलिटी कहता है, राइट. सो द गवर्नमेंट बाय स्टैट्यूट लाइक द ट्रेडमार्क एक्ट 1999, कॉपीराइट एक्ट 1957, through these also these kinds of rights of personality is being protected. For example, signature comes under the Trademark Act 1999. If any person is signing like this, so this is his signature, no one will use this signature in any commercial advertisements or anything, right. This is what rights of personality says under Article 21 of the Constitution of India, and it is protected to the various statutes like the Trademark Act, Copyright Acts. Another thing which was in news was hate speech. Hate speech. The Supreme Court wants authorities to act tough on the incitement to violence, hate speech. So the Supreme Court has said that if any person is instigating others person, means they are promoting hate crimes, they are giving such kinds of hate speeches through which violence can be erupted, right. So such things can be stopped. For example, in the Maharashtra and Chhattisgarh region, the Supreme Court has said to the police and the local administration to keep close eye on the public events planned by the Hindu Jan Jagrati Samiti, right, so that there should not be any kind of hate speech should be promoted, there should not be any kind of communal violence erupt inside the society, right. So that is there. Hate speech की अगर हम बात करें तो हेट स्पीच इट इज नॉट डिफाइंड इन एनी लॉ, कोई भी लॉ में प्रॉपरली हेट स्पीच को डिफाइन नहीं किया गया है. एंड इट इज सिंपली इंसाइटमेंट और टू द हेट्रेड प्राइमरली अगेंस्ट अ ग्रुप ऑफ पर्सन. किसी भी मेथड से हेट्रेड को फैलाना इज थ्रू द स्पीच इज हेट स्पीच, एंड नॉट ओनली स्पीच बट थ्रू एनी काइंड ऑफ इमेज, एनी काइंड ऑफ कार्टून्स, मीम्स, gestures and symbols. So we are using any method. If anyone is promoting hate speech, so that will be included inside the hate speech, and that may be punished through the various acts, right, though no act define the hate speech properly. Cannot be, it can be disseminated offline and online. Online का जमाना है, online से भी hate speech किया जा सकता है ना. तो ऑनलाइन हेट स्पीच भी हो रहा है, तो उसके थ्रू भी देखा जा सकता है कि कौन हेट स्पीच फैला रहा है. इफ यू टॉक अबाउट आर्टिकल 19 1A of the Constitution of India, it talks about right to freedom of speech and expression, right. So means every person has the right to freedom of speech and expression. They can express themselves, right, in whatever issues they want, but there is a reasonable restriction. Whatever freedom is there inside the Article 19, from Article 19 1A to 1F, right. So for that there is some kind of reasonable restrictions, and for Article 19(1)(a), the reasonable restriction is there in Article 19(2). This reasonable restrictions is that though you are free to have the freedom of speech and expression, you can express anything, you can talk about anything, right? But there will be limitations. Limitation on what? Limitation on the, if you cannot have the freedom of speech and expression, and there can be restrictions. Restriction on the basis of what? In the interest of sovereignty and integrity of India, है ना? Sovereignty और integrity of India को हैम्पर नहीं किया जा सकता है. आप इंडिया के अगेंस्ट नहीं बोल सकते, इंडिया के अगेंस्ट टेररिस्ट ऑर्गेनाइजेशंस को पनपने नहीं दिया जा सकता, राइट? सो दैट कैन नॉट बी हैपन. द सिक्योरिटी ऑफ द स्टेट, यू कैन नॉट टॉक अबाउट अगेंस्ट द स्टेट, राइट? कि हम लोग स्टेट टॉपल कर लेंगे, कॉन्स्टिट्यूशन को नहीं काम करने देंगे, राइट? स्टेट गवर्नमेंट टॉपल कर देंगे, right? So such kinds of things cannot be done. Friendly relation with the foreign states, public order, decency and morality in relation to the contempt of court. Contempt of court also, you cannot tell a spread hate against the court, means whatever the Supreme Court or whatever the High Court is telling, that is absolutely wrong, right? Supreme Court and High means they are giving means absurd kind of judgment. So such kinds of things should not be promoted, because people have lots of faith on the Supreme Court and the High Courts. Also defamation or the incitements to an offence. So these things includes the reasonable restrictions, and this also includes the restrictions on the hate speeches. There are several acts also. These acts also includes hate speeches, and if someone is promoting the hate speech, someone is instigating people, right, तो उनको फिर पनिशमेंट दिया जा सकता है थ्रू वेरियस एक्ट्स. फॉर एग्जांपल, क्रिएटिंग एनिमिटी, स्प्रेडिंग हेट्रेड etc आर पनिशेबल अंडर द भारतीय न्याय संहिता 2023. ए पर्सन कन्विक्टेड फॉर द प्रमोटिंग एनिमिटी बिटवीन द ग्रुप्स कैन बी डिस्क्वालीफाइड. अगर कोई कैंडिडेट इलेक्शन में खड़ा हो रहा है एंड दैट कैंडिडेट इज डूइंग व्हाट, हेट स्पीचेस, and that person is promoting enmity among the groups, so that person can be disqualified under the Representation of People's Act 1951, and that person cannot contest election. Protection of the Civil Right Act 1955, it penalizes the incitement to and encouragement of the untouchability, right? So if any person is instigating hate speeches against the scheduled caste and scheduled tribe population, so they can also be punished under this act. And also Religious Institution Prevention of Misuse Act 1988, it prohibits using religious premises to promote disharmony or hatred, है ना? जैसे मंदिर में, मस्जिद पे आप भोपू लगा के हेट स्पीच नहीं फैलाया जा सकता. So this will be restricted using Religious Institution Prevention of Misuse Act 1988, right? So that is there. Another thing which is in news, another thing which was in news was Places of Worship Act 1991. न्यूज में हमने पढ़ा होगा कि ज्ञानवापी मॉस्क, राइट? ज्ञानवापी मॉस्क, इट इज इन द वाराणसी. सो इन द ज्ञानवापी मॉस्क द पूजा इज गोइंग ऑन, right, using the Hindu rituals, and that has been allowed by the Varanasi court. This has been challenged in the Allahabad High Court of Uttar Pradesh. Allahabad High Court says that the puja which is being done in the Gyanvapi mosque, right, so that is completely fine, and it will not be interfering into that. So the Gyanvapi mosque case raises a challenge to the Place of the Worship Act. The 1991 Act provides a guarantee for the preservation of the religious pleasure of the character of the worship, all these things. So this was in news. So now you have to learn about the Places of Worship Act 1991, because UPSC can ask questions regarding this. ठीक है. So Place of Worship Act 1991, देखो इंडिया जब आजाद हुआ, राइट, उसके बाद जितने भी प्लेसेस ऑफ वर्शिप है, whether it is of Hindu, whether it is of Muslim, whether it is of Jain, whether it is of Parsis, so that should be protected, right? Before the India has got independence, so many of the Muslim rulers, they had broken these temples, है ना? They have destructed these temples and they have constructed mosque, and several times it has been there that mosque has been destructed and the temples has been constructed in place of that. So no such activity should be there after India's independence, right? Whatever the place of worship is there, its nature should be intact. This is the purpose of Places of Worship Act 1991. So it bars the conversion of the Places of Worship Act. It bars the conversion of places of worship. That is, if a temple is there, it cannot be converted into the mosque. If a mosque is there, it cannot be converted into a temple, right? So similar thing is there. Since when the religious character of the places of worship shall be maintained its existence on as it existed on the 15 August 1947. 15 अगस्त 1947 को क्या हुआ था? हमारा देश आजाद हुआ था. तो जिस दिन से हमारा देश आजाद हुआ, उस दिन से जिस भी प्लेस ऑफ वर्शिप का जो कैरेक्टर है, वही कैरेक्टर कंटिन्यू रहेगा. दिस इज व्हाट द प्लेसेस ऑफ वर्शिप एक्ट 1991 सेज. Any attempt to change the religious character of a place of worship is a criminal offense. If anyone is trying to convert the mosque into the temple, or trying to convert temple into the mosque, right? So such kinds of activity will be criminal activity. Such kinds of activity will be criminal offense, right? And it does not allow the government to take over the management of any places of the worship. So even the government is not allowed to take the management of any place of the worship, right? So this is there inside the act. Now you will feel कि फिर ऐसा कैसे हुआ कि बाबरी मस्जिद को कन्वर्ट करके वहाँ पे अभी राम टेम्पल बना है, प्राण प्रतिष्ठा हुआ 22 जनवरी 2024 को. हाउ वाज इट पॉसिबल? बिकॉज प्लेसेस ऑफ वर्शिप एक्ट के अंदर देयर आर सम एग्जाम्पशंस, एंड इन दैट एग्जाम्पशन अयोध्या डिस्प्यूट साइड दैट राम जन्मभूमि बाबरी मस्जिद केस हैज बीन पुट एज एन एग्जाम्पशन. सो ये वाला चीज जो यहाँ पे अगर जो भी डिसीजन आता, उस डिसीजन के थ्रू यहाँ पे टेम्पल बन सकता था, अगर डिसीजन ऐसा आया. सुप्रीम कोर्ट का जजमेंट आया कि ठीक है, यहाँ पे राम जन्मभूमि है तो यहाँ पे टेम्पल बनना चाहिए. सो अकॉर्डिंग टू दैट जजमेंट, फॉलोइंग दैट जजमेंट, वहाँ पे टेम्पल बनाया गया, राइट? सो दैट इज देयर. एंड ऑल्सो द मोन्यूमेंट्स एंड साइट्स कवर्ड बाय द एशियन मोन्यूमेंट्स एंड आर्कियोलॉजिकल साइट्स एंड रिमेन्स एक्ट 1958. तो यहाँ पे इसको भी, ये भी एग्जाम्पशन लिस्ट में है, राइट? क्योंकि आर्कियोलॉजिकल जो सर्वे होता है, आर्कियोलॉजिकल साइट्स को जो कन्वर्ट करते हैं, तो हो सकता है कि वहाँ पे अलग अलग चीजें मिले. अभी आपको नहीं पता है कि क्या है. कहीं पे लैंड है, इस लैंड के नीचे मान लो आर्कियोलॉजिकल साइट्स एक्सकवेट करती है, कहीं पे टेम्पल मिल सकता है, कहीं पे मॉस्क मिल सकता है, कुछ भी मिल सकता है. सो दैट इज एग्जाम्प्टेड. बट जो करंट कैरेक्टर है, वो कैरेक्टर जो है वो चेंज नहीं होने वाला, राइट? सो वेदर इट इज पॉसिबल टू कन्वर्ट द ज्ञानवापी मॉस्क इनटू द टेम्पल, not with this act. If that a mosque has to be converted into a temple, right, then this act has to be amended. So first of all, Places of Worship Act 1991 has to be amended. Only then Gyanvapi mosque can be converted into the temple. If at all the Supreme Court says, or the High Court says, or the community, Hindu and the Muslim community, they agree that this mosque should be converted into the temple. So obviously after that only it will be taking place. Another thing which was in news was 8th schedule of the Constitution of India, right? eighth schedule of the Constitution of India. What does this talks about? तो अगर आप देखोगे तो 8th schedule of the Constitution of India, there are 22 languages into the 8th schedule of the Constitution, and none of the language is there which is like a sign language, है ना? So that is not there, that is not included. So there was a demand, there was a urge, right? The government urged to pass the resolution to include sign language in the 8th schedule of the Constitution, and therefore this was in the news. अभी तक ये हुआ नहीं है, अभी तक 22 लैंग्वेज ही है हमारे पास in the 8th schedule of the Constitution of India, right? So let's learn, this was the news, let's learn about the 8th schedule of the Constitution of India. The 8th schedule of the Constitution of India, it enlists the official language of the country. So the original constitution, it has 14 languages, right? अभी के टाइम पे तो 22 लैंग्वेज है, लेकिन ओरिजिनली जब कॉन्स्टिट्यूशन बना था एट दैट टाइम आल्सो 8th शेड्यूल वाज देयर, राइट? 9th शेड्यूल वाज एडेड लेटर थ्रू द 73rd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. 10th शेड्यूल वाज एडेड more later, sorry, 9th schedule was added to the first constitutional amendment act. 10th schedule was added to the 52nd constitutional amendment act. 11th schedule was added to the 73rd constitutional amendment act, and 12th schedule was added to the 74th constitutional amendment act. But from the schedule 1 to schedule 8, it was already there in the original constitution, though it has been further amended. The 8th schedule has been further amended 3 times, right, to include more languages into the 8th schedule, right? Earlier there was only 14 languages. In this 14 language includes Sanskrit, Urdu, even Nepali, even Kashmiri is included in this. So that is there. 8 language was added later. So now currently there is 22 language in the 8th schedule of the Constitution. So the 21st Constitutional Amendment Act 1967, Sindhi was added in the 8th schedule, so this become the 15th language. To the 71st Constitutional Amendment Act 1992, Manipuri, Konkani, Nepali was added. So this included the 18, and later on to the 92nd Constitutional Amendment Act, Santhal, Bodo, Dogri, Santhali, Maithili was added. So this made 22 language. So currently there is only 22 language inside the 8th schedule of the Constitution of India. Please go through these languages, all the 22 languages, because many a times a student gets confused, और UPSC Prelims में ये क्वेश्चन पूछा जा सकता है कि which is included in the 8th schedule and which language is not included, है ना? जैसे included में हमने देखा कि नेपाली included है, ऐसे ही आप देखोगे तो इंग्लिश इज नॉट इंक्लूडेड इन द 8th schedule of the Constitution of India. इंग्लिश नहीं है, राजस्थानी नहीं है, हरियाणवी नहीं है, लद्दाखी नहीं है, तो थोड़ा सा केयरफुली आप लोग देख लोगे दैट which all languages are there in the 8th schedule of the Constitution of India. Please remember all 22 language. At any given point of time prelims में ये questions आ सकता है. Another thing which was in news was 9th schedule of the Constitution of India. Right. 9th schedule of the Constitution of India, it was added to the first Constitutional Amendment Act, right? And जो main जो पर्पस था 9th शेड्यूल का, सो दैट वाज लैंड रिफॉर्म को इम्प्लीमेंट करना. लैंड इज ए स्टेट सब्जेक्ट एंड देयरफॉर सेवरल एक्ट्स फ्रॉम द स्टेट गवर्नमेंट्स, फॉर एग्जांपल केरला लैंड रिफॉर्म एक्ट, बिहार लैंड रिफॉर्म एक्ट, सो दिस काइंड्स ऑफ एक्ट्स it has been put into the 9th schedule of the constitution, so that these acts cannot be questioned, there cannot be judicial review, right? These acts cannot be questioned if it, even if it violates the fundamental rights, that is right to property of the citizen of the country. At that point of time, right to property was the fundamental right. ठीक है, so that is there. Now कर्नाटका गवर्नमेंट ये न्यूज में जो था, that is there. So न्यूज में इसलिए था because कर्नाटका गवर्नमेंट has made an act in which it has extended the quota for scheduled castes and scheduled tribes, and the Karnataka government should wants that this act, ये जो एक्ट लेके आई थी, जिस एक्ट के थ्रू SC/ST का कोटा इनहेंस हुआ, ये एक्ट, इस एक्ट को क्या किया जाना चाहिए, 9th शेड्यूल में डाल दिया जाना चाहिए. सो 9th शेड्यूल में डालने से क्या होगा, दिस विल बी इम्यून, राइट, नॉट 100% इम्यून, because later on it was decided that judicial review will be there, and judicial review will be there to check the constitutionality of the act which is being put inside the 9th schedule. What does this mean? This means that whether the act which is being put inside the 9th schedule, whether that act is violating the basic structure of the constitution or not, whether they are violating the basic feature of the constitution or not, right? Therefore 9th schedule में ये चीजें ऐड करने की कर्नाटका गवर्नमेंट रिकमेंड करती है कि इन्होंने जो लॉ बनाई है उसको आप 9th शेड्यूल में डाल दो. ठीक है, अभी तक ये डला नहीं है, बट स्टिल 9th शेड्यूल के बारे में हम लोग थोड़ा सा देखते हैं. सो इट वाज एडेड टू द फर्स्ट कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, एंड द मेन पर्सन वाज टू bring this 9th schedule was to implement the land reform acts, because at that point of time the right to property was the fundamental rights, and if any land reform act was being implemented, it was violating the fundamental right to property. So eliminating this thing, because land reform act has to be implemented, this is compulsory. There has already been lots of problem, zamindari system, jagirdari system, all those things has been abolished after the independence, but the thing is still only few families used to hold thousands and thousands of acres of land, right? So that needs to be reorganized. So it was introduced during the prime ministership of the Jawaharlal Nehru. It was obviously this was the first constitutional amendment in 1951. So at that time Jawaharlal Nehru was the prime minister. It inserted the Article 31B of the Constitution of India. What does this Article 31B says? Article 31B says that whatever will be inside this schedule, 9th schedule, whatever acts will be inside this 9th schedule, there cannot be judicial review on those acts, right? Their constitutionality cannot be questioned, right, in the court. So this was the purpose of article, this was the saying of the Article 31B of the Constitution of India. Initially there was only 13 law has been put in the 9th schedule. Right now 284 law have been put inside the 9th schedule of the Constitution of India, right? कहाँ पे 13 और कहाँ पे 284, you can see the difference. ठीक है. Now पहले तो होता था कब तक, 24 अप्रैल 1973. ठीक है. तो एक केस आया आयर कोयलो केस 2007 में. जब तक ये केस नहीं आया था, till then what was happening, that it was said that the whatever act is put in the 9th schedule of the Constitution, that will be completely away from the judicial review. There will not be any kind of judicial review, right? In the IR Coelho case, it was said that as the basic structure doctrine came. Basic structure doctrine came on the 24 April 1973. Why? Because on 24 April 1973, the final judgment of Kesavanand Bharati case came. So the Kesavanand Bharati case itself, basic structure doctrine came. So as per the IR Coelho case, the 9th schedule is not immune to the judicial review. Means you will have to check whether it is constitutionally valid or not, whether any law is violating, whether any law which is put inside, means this 284 law, whether whichever law which is being put inside the 9th schedule of the Constitution of India, so whether that is violating the basic structure doctrine or not, whether that is violating the Constitution of India or not, so that is being checked. So the law placed in the 9th schedule is unconstitutional if it violates any fundamental rights and it violates the basic structure doctrine, right? So this has been put, और ये बोला गया कि 24 अप्रैल 1973 के बाद जितने भी एक्ट्स आए उन सब को का कॉन्स्टिट्यूशनलिटी चेक किया जाएगा, right, whether they are passing this basic structure test or not, right? So now the judicial review is there. Another thing which was in news was reservation for the locals in the private sector jobs. You must have heard that several states, for example, Andhra Pradesh, Madhya Pradesh, Jharkhand, right, Maharashtra, so they are trying to bring reservation for locals in private sector jobs. On the similar lines, Haryana has also provided, Haryana had provided 75% private sector jobs, reservation for the 75% private sector jobs for the locals only, means only for the people of Haryana, right? Now this thing has been questioned in the High Court, Punjab and Haryana High Court, it was questioned, and Punjab and Haryana High Court has said that this kind of reservation which is guaranteeing reservation to the locals in private sector jobs are unconstitutional in nature. So there should not be any kind of things like this happening inside our country. Means it says that the such reservation is unconstitutional as it is violating the part 3 of the Constitution of India, and more importantly it is violating the article 15 and 16 of the Constitution of India, because article 15 and 16 it talks about, means there should not be any kind of discrimination on the basis of race, religion, caste, sex, place of birth, right? So if anyone is, if any state government is having reservation, right, so they are having reservation on the basis of domicile, on the basis of residence, so that kind of reservation for the private sector jobs for the locals is unconstitutional in nature. This is what the Punjab and Haryana High Court has to say, right? If you see article 16(3), it talks about the Parliament has the power to make such laws, not any state legislature, but obviously if हरियाणा के अंदर कुछ इम्प्लीमेंट करना है तो वहाँ पे हरियाणा स्टेट लेजिस्लेचर ने ब्रिंग किया ये 75% रिजर्वेशन वाला, ठीक है, तो वो तो प्रोविजंस ऐसे ही गलत हो गया, ठीक है. सो दिस इज अगेंस्ट द कॉन्स्टिट्यूशनल मोरालिटी because there is some kind of negative discrimination is being posed. What does the Constitution says? The Constitution says that everyone is equal, right to equality, right? So that is there. Plus there should not be any kind of discrimination on the basis of race, religion, caste, sex, place of birth, as well as the descent also. So if any reservation is provided just on the basis of domicile, So that kind of reservation will be unconstitutional in nature. This is what the High Court has to say. Another thing which was in news was Article 355 of the Constitution of India. The High Court says that it is not empowered to issue a direction for invocation of Article 355 of the Constitution of India rules the judges. हुआ ये था कि तमिलनाडु के अंदर, राइट, तमिलनाडु के अंदर एक मिनिस्टर्स हैं, एक मिनिस्टर हैं सेंथिल बालाजी। सेंथिल बालाजी जो मिनिस्टर्स हैं उनके ब्रदर के घर पे इनकम टैक्स ऑफिशियल ने रेड किया था। तो इनकम टैक्स ऑफिशियल्स के को उनके ऊपर अटैक कर दिया गया था, राइट। द पीपल अटैक्ड द इनकम टैक्स ऑफिशियल्स हु हैड रेडेड द ए मिनिस्टर दैट इज सेंथिल बालाजी's brother's house. So there was an urge that in this case Article 355 of the Constitution should be implemented, right, and therefore the issue has went into the Tamil Nadu High Court. The Tamil Nadu judges in the Tamil Nadu High Court has clearly said that this is not the matter of the Article 355 of the Constitution of India, and we are not entitled means the judges or the Tamil Nadu High Court is not entitled, they are not empowered to implement Article 355 of the Constitution of India in this regard. Okay, so this was the total issue. Now what you have to study for the prelims point of view? So you have to now study what is there inside the Article 355 of the Constitution of India. Article 355 of the Constitution of India, as you know, it is coming under the emergency provisions. From Article 352 to Article 360 of the Constitution of India, there is emergency provisions, right. So under Article 355 also there is such kinds of provisions, means it is the duty of the union to protect states against the external aggression and internal disturbance. So union will be protecting the states against the external aggression and the internal disturbance, right. It shall be the duty of the union to protect every state against the external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provision of the Constitution. So what was being said, that as the Tamil Nadu government's IT officials, they are government officials, and if they are being attacked, means constitutional machinery has failed, and constitutional machinery has failed, so Article 355 should be implemented. But High Court has said that we cannot implement it like this, right. ऐसे नहीं किया जा सकता है। तो इन जनरल अगर ये यूनियन एग्जीक्यूटिव्स को ये रिस्पॉन्सिबिलिटी है, यूनियन के पास ये रिस्पॉन्सिबिलिटी है, यूनियन गवर्नमेंट की ये रिस्पॉन्सिबिलिटी है कि वो स्टेट का किसी भी एक्सटर्नल एग्रेशन और इंटरनल डिस्टर्बेंस के कारण अगर कोई इशू उठता है तो उससे प्रोटेक्ट करना है। एक्सटर्नल एग्रेशन के कारण आपको पता है कि क्या हो सकता है, आर्टिकल 352 का लगाया जा सकता है, और वहां पे वार, एक्सटर्नल एग्रेशन एंड आर्म्ड रिबेलियन, इसके लिए आर्टिकल 352 लग सकता है, मींस नेशनल इमरजेंसी लग सकता है, राइट। इंटरनल डिस्टर्बेंस पहले था ये अप टू 44th कॉन्स्टिट्यूशनल अमेंडमेंट, इंटरनल डिस्टर्बेंस के लिए भी लगाया जा सकता था नेशनल इमरजेंसी, बट नाउ national emergency cannot be applied for the internal disturbance, right. Now internal disturbance को remove करके क्या word ला दिया गया है, that is armed rebellion, ठीक है, तो actually using Article 355 of the Constitution of India, the Union government is protecting the states. और यही कारण है कि आर्म फोर्सेस स्पेशल पावर एक्ट लगता है बहुत सारे स्टेट्स में, फॉर एग्जांपल इन द नॉर्थ ईस्टर्न स्टेट्स, राइट. सो टू सेव द कॉन्स्टिट्यूशनल मेशनरी, दिस आर्म फोर्सेस स्पेशल पावर एक्ट इज बीइंग इम्प्लीमेंटेड, राइट, ताकि एक्सटर्नल एग्रेशन या इंटरनल डिस्टर्बेंस जो उस पर्टिकुलर स्टेट के अंदर हो रहा है उसको बचाया जा सके, राइट. So it emphasizes the importance of state security and integrity. So states has to be secured, its safety has to be taken care of, and therefore Article 355 can be implemented if there is external aggression or if there is internal disturbance going on inside any state, and in that case the central government or the union government has this responsibility. ठीक है, external aggression के लिए तो नेशनल इमरजेंसी तक भी अप्लाई किया जा सकता है थ्रू द प्रेसिडेंट, राइट. होप दिस इज क्लियर टू यू. Another thing which was in news was Ladakh. Recently you have seen that the Sonam Wangchuk, he is the same person on which the 388 मूवी के अंदर जो रेंचो है, आमिर खान का जो कैरेक्टर है वो सोनम वांगचुक से इम्प्रेस्ड होके, इंस्पायर्ड होके लिया गया, राइट. सो दैट पर्सन हैज बीन कंटिन्यूअसली ऑन फास्ट, 21 डेज का फास्ट उन्होंने रखा था टू प्रोटेक्ट द इन्वायरमेंट ऑफ लद्दाख. एक्चुअली दे हैव बीन डिमांडिंग 4 things. What is those 4 things? Like, first thing is Ladakh should be made a separate state. Yes, statehood should be provided to the Ladakh. Second thing is Ladakh should be given the 6th schedule status, right. Third thing is there should be public service commission which should be set up inside the Ladakh, और उसके थ्रू वो पब्लिक सर्वेंट्स को चूज कर पाए. एंड देयर शुड बी, फोर्थ थिंग इज फ्रॉम द लद्दाख देयर शुड बी एटलीस्ट 2 members which should come inside the Lok Sabha. Right now there is only 1 member which is coming from the Lok Sabha from the Ladakh, right. And therefore we had seen that therefore as इतना बड़ा टेरिटोरी है लद्दाख का टेरिटोरी, है ना, फ्रॉम ईस्ट टू वेस्ट, इस कारण से वो सबसे बड़ा लार्जेस्ट कॉन्स्टिट्यूएंसी ऑफ इंडिया बन जाता है. एंड लद्दाखीज का ये डिमांड है कि फ्रॉम द लद्दाख रीजन देयर शुड बी एटलीस्ट 2 person which should be there in the लोक सभा. तो ये 4 डिमांड था, जिस डिमांड को लेके सोनम वांगचुक ने 21 डेज का फास्ट रखा था. अभी तक वो डिमांड को फुलफिल नहीं किया गया है, बट दिस लद्दाख हैज बीन इन न्यूज कंटिन्यूअसली, right, because they feel cheated that they have not been, whatever has been promised to them, so that has not been fulfilled by the central government till now, right. तो एक इसी प्रोसेस के थ्रू, है ना, एक इस ये भी चल रहा था कि लद्दाख कैन बी पुट अंडर द आर्टिकल 371 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया. सो व्हाट इज दिस आर्टिकल 371? आर्टिकल 371 of the constitution of India, it gives a special status, not means it gives some kind of specific provisions, some kind of special autonomy to these particular states, right. So article 371 of the constitution, it is from the article 371 A, B, C, D, E, F, G, H, I, right, and it is there for the states like the Nagaland, Assam, Manipur, Andhra Pradesh, Sikkim, Mizoram, Arunachal Pradesh and Goa, right. This is to provide some kind of safety and security to that state. This is to provide some kind of religious and cultural security to the people of those states, right. और ऐसा नहीं है कि सारे आर्टिकल 371 A, B, C सब में सिमिलर टाइप का प्रोविजंस है, ऐसा नहीं है, सब में अलग अलग तरह का प्रोविजंस है. स्पेसिफिक प्रोविजंस which is particularly required in that particular area, that has been provided. More importantly, it is the autonomous, the region is being more autonomous region, right. so that the whatever the laws which is being implemented by the central government, which is being implemented by the state government, तो वो उस laws को थोड़ा modify करके उन सब areas में लगाया जा सकता है या नहीं भी लगाया जा सकता है. So this is the requirement. So Article 371A, you do not have to go into very much details for the prelims point of view. Please remember this, that Article 371A talks about the Nagaland, B talks about the Assam, C talks about the Manipur, D talks about the Andhra Pradesh and Telangana, E talks about the establishment of central university in the Andhra Pradesh, F talks about the Sikkim, G talks about the Mizoram, H talks about the Arunachal Pradesh and I talks about the Goa. सारे आर्टिकल्स में अलग अलग टाइप के प्रोविजंस हैं. कहीं पे कल्चरल एंड रिलीजियस आइडेंटिटी को प्रोटेक्ट करने के लिए है, कहीं पे ज़्यादा ऑटोनॉमी देने के लिए है. तो अलग अलग चीज़ें जो हैं वो यहाँ पे लगाया गया है, रखा गया है. राइट, दीज आर टेम्पोररी, ट्रांजिशनल एंड स्पेसिफिक प्रोविजंस, special provisions which has been provided. So these are not permanent, as we have seen that Article 370 of the Constitution, right, that has been abrogated. So it operates till the crisis ceases. लेकिन कोई डेडलाइन नहीं दिया गया है कि अब बाई 2030 इट विल बी फिनिश्ड, या 15 साल में ये खत्म हो जाएगा, 20 साल में ये खत्म हो जाएगा, ऐसा कोई डेडलाइन नहीं दिया गया है. बट द थिंग इज दीज आर टेम्पोररी इन नेचर. आज न कल परसों कभी ना कभी जाके ये 10 साल बाद, 20 साल बाद, 50 साल बाद, 100 साल बाद कभी ना कभी जाके ये सारे प्रोविजन जो है वो खत्म हो जाएंगे. राइट, सो दैट इज देयर. द नेक्स्ट थिंग विच वाज इन न्यूज वाज नो कॉन्फिडेंस मोशन. लास्ट ईयर जुलाई में नो कॉन्फिडेंस मोशन लगा था एंड ये अपोजिशन पार्टीज के द्वारा लगाया गया था नो कॉन्फिडेंस मोशन. दिस मोशन हैज बीन पुट फॉरवर्ड, राइट, सो इन द लोकसभा. सो व्हाट इज दिस नो कॉन्फिडेंस मोशन, हाउ इज इट बीइंग इंप्लीमेंटेड? राइट, it is a tool to express the lack of confidence in the government. No confidence motion means we do not have confidence on the government. We do not have the confidence on the government that the government is in majority. Right. So that is being questioned in this motion. It is a tool to express that there is a lack of confidence in the motion. The motion is moved in the Lok Sabha only to test the majority of the government, right? For example, 543 seats is there in the Lok Sabha. So for that, at least 272 plus should be there for any particular party to run the government, to make the Council of Ministers, to become the Prime Minister, right? Therefore, if any person, means not any person, means if any political party which is ruling the government, if any given point of time it is being felt that the confidence is not there on the government, means it is the, if they have the majority of this 272 plus or not, if that is in question, then no confidence motion will be brought up. और आपको ये भी बता दें कि कोई भी नो कॉन्फिडेंस मोशन जो है अभी तक पास नहीं हुआ. So it requires the support of the minimum 50 MPs to be admitted and discussed in the House. So at least 50 MPs should accept that yes, no confidence motion should be brought up inside the Lok Sabha of the Parliament, right? It is only brought in the Lok Sabha only because Lok Sabha के अंदर से ही गवर्नमेंट बनता है ना. ऐसे तो राज्यसभा का भी मिनिस्टर्स हो सकते हैं, बट मेनली जो है वो मेजोरिटी कहीं कहाँ पे होना चाहिए, लोकसभा के अंदर होना चाहिए। लोकसभा के अंदर आउट ऑफ 543 272 प्लस मेंबर्स होना चाहिए किसी भी पार्टी के लिए to form the government, right? Therefore it will be brought only in the Lok Sabha and not in the Raj Sabha, because it is being said that the council of ministers, they are collectively responsible to the Lok Sabha, not to the parliament. The council of ministers are not collectively responsible to the Raj Sabha, they are collectively responsible to the Lok Sabha. इसलिए नो कॉन्फिडेंस मोशन कहाँ पे आएगा, सिर्फ और सिर्फ लोकसभा के अंदर आएगा, राइट। और जब ये 50 मेंबर्स दे देंगे तो स्पीकर डिसाइड्स वेदर द मोशन इज इन ऑर्डर और नॉट। स्पीकर डिसाइड करेंगे कि मोशन लाना है कि नहीं लाना है। जैसे अभी आपने न्यूज में देखा था दैट लोकसभा स्पीकर जो है वो एक्सेप्ट कर लिए, लोकसभा स्पीकर एक्सेप्ट, सो इट इज द power of the Lok Sabha speaker whether to accept it or not. So speaker decides whether the motion is in order or not. If passed, अगर no confidence motion pass हो गया, right, इसका क्या मतलब है, इसका क्या मतलब है कि गवर्नमेंट मेजोरिटी में नहीं है। अगर किसी भी गवर्नमेंट को 272 प्लस मेंबर्स होंगे तो कभी भी नो कॉन्फिडेंस मोशन पास हो ही नहीं सकता, राइट। But if the no confidence motion is passing, that means that the government which is being formed is not in the majority. तो इस केस में क्या होगा, प्राइम मिनिस्टर एंड द काउंसिल ऑफ मिनिस्टर्स इन सबको रिजाइन करना पड़ेगा, राइट। सो दे विल हैव टू रिजाइन। वेदर देयर इज नीड टू से कि on what ground no confidence motion is being brought up, there is no need to say that on what ground no confidence motion is being brought up. बस 50 मेंबर्स चाहिए, 50 MP चाहिए from the Lok Sabha, they should give in writing that no confidence motion should be brought, and this is being brought because Article 75(3) of the Constitution of India, it says that the Council of Ministers are collectively responsible to the Lok Sabha. As they are collectively responsible to the Lok Sabha, therefore it is the Lok Sabha which will see whether there will be confidence of government or not, right। इसीलिए नो कॉन्फिडेंस मोशन लाया जाता है। So next thing which was in news was parliamentary privileges. Bribe to vote. Bribe to vote. Just imagine the member of parliament, they are taking bribes to vote inside the parliament. How much bad it is for the democracy, how much bad it is for our parliament, right। और कितना बड़ा धोखा है ये पीपल ऑफ इंडिया के लिए कि जिस रिप्रेजेंटेटिव को लोगों ने चुन के भेजा है वो क्या कर रहे हैं, ब्राइब लेके वोट कर रहे हैं। Therefore the Supreme Court has said that the immunity, the privileges which is being enjoyed by the parliamentarians, right, that immunity will not be there for the bribes to vote, because bribe to vote will be a ये केस में एक ये क्रिमिनल प्रोसिक्यूशन होगा, बिकॉज ये क्या है, एक क्रिमिनल ऑफेंस है, राइट, यही बोला है। सो लेट्स अंडरस्टैंड दिस प्रिविलेज थिंग। आर्टिकल 105 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया, it talks about the parliamentary privileges. Means the member of parliament will have the privilege of what kind? Freedom of speech and expression. They can do any kind of discussion inside the parliament. they can vote as per their own will, right, or as per the whip which is being set by all the political parties, whip, right. तो इसके थ्रू वो वोट करेंगे. Similarly, Article 194 of the Constitution of India, it talks about the privileges and immunity of the member of the state legislature. So state legislature के privileges को कौन सा आर्टिकल देता है? आर्टिकल 194. और ये why these privileges are there? Because these member of parliaments, they should not be under any pressure, they should not be under any fear, right, that whatever they are being discussing inside the parliament, they will be penalized for that. So there is very much requirement of freedom of speech and expression. But at what level? Does these privileges allow a person to take bribe and to vote in the parliament? Obviously not, right. So the freedom of speech in the parliament is there, right to publish debates, the proceeding, all these things there. Also there is Article 118 of the Constitution of India, that is the freedom of speech and expression, which is ensured through the Article 19(1)(a) of the Constitution of India, right, that is there, is subject to the rules and procedures of the parliament. So if the parliament is forming some rules and regulations, for example, Lok Sabha will have some kinds of rules, Rajya Sabha will have some kinds of rules, right. So according to that rules and regulations, all the parliamentarians will have to they will have to play their role, right. So that will be there. So if any rules and regulations is being formed by the Lok Sabha or the Rajya Sabha or jointly, so that rules and regulation has to be followed by the all parliamentarians. Whether these privileges has been codified in any statutes, any law, any constitution or any rules of procedure, so these privileges has not been codified because of the complexity. ठीक है. If it will be codified, then what will be coming under the privileges and what will not be coming under the privileges, that will be very tough to judge. So time to time, whether anything is inside the privileges or not, that is being decided by the privilege committee. So लोक सभा के अंदर अलग से privilege committee होगा, राज्यसभा के अंदर अलग से privilege committee होगा. जब भी कोई breach of privilege होगा, this privilege committee will look into the matter and they will decide whether there has been breach of privileges or not, right. But another thing, that is, ये तो parliament के through हो गया, parliamentary committee है ना, this is parliamentary provisions. Beyond parliament also, if something is done that is of the criminal nature, then judiciary will come into the picture. Right, judiciary will come into the picture. For example, bribe for vote. Bribe for vote is a criminal offense. So judiciary will decide for what should be the punishment given to that member of parliament who has breached privileges like this. ठीक है. So hope you have understood this parliamentary privileges and its breach. Parliament, what is the function of the parliamentary committee, what are the constitutional articles, whether the privilege and immunity is being mentioned in the constitution or not. Yes, it is mentioned under Article 105 for the member of parliament and Article 194 for the member of state legislature, but privileges has not been codified anywhere, neither in the constitution nor in the rules and procedures of the Lok Sabha or the Rajya Sabha, right. The next thing which was in news, because there was a record breaking suspension of 146 MPs. Please look carefully. What is it? Suspension. It is not disqualification. There is difference between disqualification and suspension. Later on we will be reading this. ठीक है. So अभी बात हो रहा है सस्पेंशन का. 146 MPs को सस्पेंड कर दिया गया था, लोकसभा और राज्यसभा दोनों को मिला के, राइट. तो टोटल में से 146 MPs वाज डिस्क्वालिफाइड, क्योंकि ये सब क्या कर रहे थे, बहुत तरह की चीजें, वो बैनर लेके घुस गए थे पार्लियामेंट के अंदर. So that is being there. Now let's talk about the suspension. What are the constitutional basis for the expulsion? Or this is suspension. Expulsion is different. If a member of parliament, whether from the Lok Sabha or the Rajya Sabha, whether they have done breach of privileges, whether they have done contempt of the house means contempt of the Lok Sabha, contempt of the Rajya Sabha, they are not letting the speaker maintain the decorum of the house, they are not letting the house function, right. So that is happening. A simple majority is needed to pass a motion for expulsion in each house. So that is another process, that is a person can be expelled from the house also. So that is there. Ethics committee is there, just like the privilege committee, ethics committee is also there. Ethics committee is also there in the for the Lok Sabha. Separately, ethics committee is also there for the Rajya Sabha. So this ethics committee, what will be the responsibility of this ethics committee? They will be there. They will be checking whether the act of member of parliament is ethical in nature or not, right. And if it is not ethical in nature, the member of parliament can be expelled, they can be suspended, even in worst case they can be disqualified also. Article 122 of the Constitution of India, it provides immunity to the parliamentary proceedings from judicial scrutiny based on the procedural irregularity. What does this mean? This means that whatever proceedings inside the parliament is going on, that cannot be questioned inside any court of the land, neither in the High Court, nor in the Supreme Court, or not in any court. Those discussions cannot be questioned. It cannot be said as why such particular MP has discussed any matter like that, right, because they have the privileges, they have the freedom of speech and expression. ठीक है, तो सस्पेंशन हो सकता है, right, if breach of privileges is happening, और ये सब breach of privileges is happening, contempt of the whole house is happening, तो simple majority के through suspension किया जा सकता है. The duration of suspension. The duration of suspension will be for the maximum period of 1 session. 3 session होता है पार्लियामेंट के अंदर, बजट सेशन, मॉनसून सेशन एंड विंटर सेशन. तो एट एनी पर्टिकुलर टाइम a member of parliament can be suspended for the maximum time period of that particular session only, right. So there is difference between the disqualification, suspension and expulsion. एक्सपल्सन अगर आप देखेंगे तो एक मेंबर ऑफ पार्लियामेंट थी लोकसभा के अंदर, दैट वाज महुआ मोइत्रा, एंड शी हैज बीन एक्सपेल्ड फ्रॉम द लोकसभा बिकॉज ऑफ कैश फॉर क्वेरी. This was also in news. This why? Because she has been taking some kind of this cash or kinds, right, to ask question in the Lok Sabha, right? So that is very unethical thing. Ethics committee has found it very unethical. Then there was one motion was passed, and through that motion the Moa Moitra was expelled from the house for this complete Lok Sabha, all sessions of the Lok Sabha, right? और क्या डिफरेंस होता है इन तीनों में? डिफरेंस ये है कि डिस्क्वालिफिकेशन, एक बार जो पर्सन डिस्क्वालीफाई हो गया, दे कैन नॉट कंटेस्ट द इलेक्शन, बट इन केस ऑफ सस्पेंशन एंड एक्सपल्सन द पर्सन कैन कंटेस्ट द इलेक्शन. इसीलिए आप देखोगे कि दो Mahua Moitra has been expelled. She was from the MP from the Trinamool Congress. So though she has been expelled in earlier Lok Sabha, but once again in 2024 Lok Sabha election of 2024, she is once again contesting election, right? So that is possible. So expulsion के केस में लोकसभा वापस से कॉन्टेस्ट किया जा सकता है, इलेक्शन कॉन्टेस्ट किया जा सकता है. सस्पेंशन के केस में सस्पेंशन तो मैक्सिमम एक सेशन के लिए ही होता है, तो सस्पेंशन में तो वापस रिवोक हो जाते हैं, फिर से लोग आ ही जाते हैं. जितने भी 146 MPs वर सस्पेंडेड, तो दे केम बैक इन अनदर सेशन. एंड बहुत बार तो सेशन का वेट कंप्लीट होने का भी वेट नहीं किया जा सकता है, अनदर मोशन से उन सबका सस्पेंशन कैंसिल भी किया जा सकता है, राइट? सो दैट इज देयर. डिस्क्वालिफिकेशन को और डिटेल में हम लोग पढ़ने वाले हैं. तो डिस्क्वालिफिकेशन अलग अलग मेथड से होता है, सो वी विल बी लुकिंग इनटू दिस. होप दिस इज क्लियर टू यू. एंटी-डिफेक्शन लॉ 10th शेड्यूल, दिस हैज आल्सो बीन इन न्यूज. द हेलोइंग आउट ऑफ द एंटी-डिफेक्शन लॉ. इसमें एक कॉन्सेप्ट है मर्जर का. पहले तो कॉन्सेप्ट था स्प्लिट का, बाद में स्प्लिट का कॉन्सेप्ट हटा के लाया गया मर्जर का, राइट? स्प्लिट में क्या होता था कि मान लो 150 मेंबर्स हैं, तो इसका 1/3 अगर 50 मेंबर्स चाहें तो वो पार्टी से अलग हो सकते हैं, नया पार्टी बना सकते हैं, किसी और पार्टी में जा सकते हैं. सो दैट वाज स्प्लिट. ये स्प्लिट को रोक दिया गया. अब नया कॉन्सेप्ट लाया गया, दैट वाज मर्जर. Through the merger now 2/3 is required out of 150. If 100 people agree that we should go to another party, we should form new party, then that can be done. ठीक है. So anti-defection law was in news also. So what are the grounds for anti-defection? First, for that to understand, you should understand कि how this MP are becoming. देखो, कोई भी जो मेंबर ऑफ पार्लियामेंट बनता है, ठीक है, तो वो किस तरह से बन सकता है? या तो वो इलेक्टेड है या वो नॉमिनेटेड है, राइट? अगर इलेक्टेड है तो उसमें किसी पार्टी का होगा या किसी कोई इंडिविजुअल लड़ा होगा इलेक्शन. यही तरीका है टू बिकम द मेंबर ऑफ दिस पार्लियामेंट, इजंट इट? तो अगर कोई मेंबर ऑफ पार्लियामेंट बनता है एंड दैट पर्सन इज नॉमिनेटेड, so that person will get some kind of liberty that if within the 6 months that nominated person join any political party, that will not be disqualified, that person will not be disqualified. But after 6 months, if this nominated person gets joins any particular party, then that person will be disqualified. ठीक है, that person will be disqualified if after 6 months they join any party. Now come to this part. If any person is elected from any party, for example BJP, right? So if any person is elected from the BJP and he came into the Lok Sabha, now that person is changing the party. That person is going from the BJP to the Congress, right? So in this case what will be happening? Anti-defection law will be applied and that person will be disqualified. ठीक है. इंडिविजुअल के केस में इफ द इंडिविजुअल पर्सन ज्वाइंस एनी पार्टी, इंडिविजुअल पर्सन कौन होता है? जो किसी भी पार्टी लाइन से नहीं होता, वो इंडिविजुअली खड़ा हुआ एंड उसने इलेक्शन कंडक्ट लड़ी, राइट, कॉन्टेस्ट किया और वो जीत के आया. अब वो जीत के आ गया, उसके बाद वो कोई पॉलिटिकल पार्टी ज्वाइन कर ले रहा है, सो दैट इज नॉट अलाउड. दैट विल बी कमिंग अंडर द एंटी डिफेक्शन law. That will be considered as a defection. So this person will not be allowed to go into another party, not in any party. ठीक है, ये तीनों सिनेरियो समझ में आया. Then another scenario is कि every member of parliament they will have to vote as per their political party's will, right? And the person which is allocated for that is called whip. So whatever the whip says, all the members have to follow that whip, and if the whip says to vote for any particular thing, so they will be voting. If they will be whip says that not vote, they will not be voting. If they say that vote for the yes, they will be voting for the yes. If they say that vote for the no, everyone, a member of parliament of that particular party, will be voting for the no. But if any person, any member of parliament, they are not accepting the decision of the whip and going against the whip, in that case also anti-defection will be applied, right? So hope this is clear to you. Earlier there was the concept of a split. In the split, if 1/3 member wanted to go to different party or make another party, right, so that was possible. But through the 91st Constitutional Amendment Act, 91st Constitutional Amendment Act, a defection by the 2/3 split has been eliminated and merger concept came. Now 2/3 of the elected members of the political party was considered a merger. So if 2/3, if any political party is there and its 2/3 members is willing to go to form different party, or they are willing to go to join another party, right, so that will be allowed. That will not be considered as the defection under the anti-defection law. Who decides anti-defection law? Right, who decides the cases under the anti-defection law? It will be the chairperson. For the Rajya Sabha it is the chairman, for the Lok Sabha it is the speaker, right? In the Kyoto Holohan case 1992, it was said that the decision of the speaker and the chairperson is subject to the judicial review. So whatever the decision is being taken by the chairman of the Rajya Sabha or the speaker of the Lok Sabha regarding the anti-defection law, right, so that will be under the judicial review, right? So that has been said. Anti-defection law, it came to the 52nd Constitutional Amendment Act, and it has brought the 10th schedule of the Constitution of India, right, in 1985. Hope this is clear to you. One thing also here I would like to clear, that disqualification of a member of parliament can happen through the 3 ways. disqualification. For the disqualification, there is some kind of constitutional provisions also. Constitutional provisions. For example, the person will have to be a citizen of India. If the person is losing the citizen of India, then that person will automatically be removed from the member of parliament, right? The person should not be should be of sound mind. He should not be the unsound mind. He should not be bankrupt, undischarged solvent, right? So such kinds of disqualification, methods of disqualification is there inside the Constitution of India. Another few kinds of methods of disqualification is there inside the Representation of People's Act 1951. So if any person is disqualified using this provision, for example, the section 8, 9, 10, 11 of Representation of People's Act, it talks about disqualification. For example, corrupt practices is being followed. So regarding that, if a person is being disqualified using the Representation of People's Act, so they are violating those sections, so that will also be there. And third is anti-defection law. Right. So these are the three ways on which a member of parliament can be disqualified. Right. For these two methods of disqualification, who is the deciding authority? President. President is the deciding authority. And for anti-defection law, who is the deciding authority? Presiding officer. In case of Rajya Sabha, it will be chairman. In case of Lok Sabha, it will be the speaker. Right. So that is there. I hope this is clear to you. Another thing which was in news was ordinance. अभी जो हमने देखा था ना, वो गवर्नमेंट ऑफ नेशनल कैपिटल टेरिटोरी ऑफ दिल्ली अमेंडमेंट, ये ऑर्डिनेंस के थ्रू लाया गया था, राइट? सो व्हाट इज दिस ऑर्डिनेंस and who can issue this ordinance? So first thing is the President of India and the governor of each state, they can bring the ordinances, but there is some limitation. Whenever both the houses are in session, means in case of parliament, when the Lok Sabha and the Rajya Sabha both are in session, in that case the ordinances cannot be brought. In case of states, when the legislative assembly is in session, the ordinance cannot be brought. But when either of the house, either Lok Sabha or Rajya Sabha, if they are not in the session, then ordinance can be brought. Why? Because a bill has to be passed both by the Lok Sabha and the Rajya Sabha, only then it will go to the president, and after the assent of the president, the bill will become act. But if any session, any house is not in the session, it is impossible to become a bill to become a act, right? For that scenario, ordinance provisions are there. So under Article 123 of the Constitution of India, the President of India has the power to issue an ordinances. Similarly, Article 213 of the Constitution of India, Governor of each states has the power to issue ordinances, but it can only be issued only when both the houses are not in the session, or either of the houses are not in the session. But let's suppose now ordinance has been passed. So whether that ordinance has to be passed by the Lok Sabha and the Rajya Sabha again? Yes. After the ordinance has been passed, after the ordinance has came into the existence, once Lok Sabha and the Rajya Sabha, once they sit back, so within 6 weeks that ordinance has to be passed, else that ordinance will be nullified, right? So that is there. So ordinance has to be passed by the Parliament, both Lok Sabha and the Rajya Sabha, within 6 weeks. Similarly, for the ordinances passed by the governor, the Legislative Assembly has to pass it within the 6 weeks. Another thing is, ordinance cannot be used for amending the constitution, right? For amending the constitution, constitutional amendment bill will be produced, and that will be coming in the Lok Sabha, either in the Lok Sabha or in the Rajya Sabha. But once it is being passed by both the houses, it will go to the president, and president will have to mandatorily give its assent on the constitutional amendment bill. There is no veto which is being enjoyed by the president in case of constitutional amendment bill, right? So ordinance cannot be issued for the amending the constitution. The maximum life of ordinance is 6 months and 6 weeks. Why this 6 months? 6 months because it is written inside the Constitution of India that within a year each house has to sit at least twice. Means there should be at least 2 sessions which must be held of any house of the Parliament, right, in a year. That means the maximum time period for which a particular house will not be in the session is 6 months, है ना? तभी तो एक साल के अंदर दो बार होगा. So maximum time period will be 6 months, और 6 week यहाँ पे allowed है, तो 6 months plus 6 week will be there, subject to the same limitations at the Parliament or this. Now it's not that through the ordinances absolutely each or anything can be done. For example, the Parliament cannot make any law which is violating the basic structure doctrine, which is violating the basic feature of the Constitution of India, right? So even through the ordinances, any ordinance cannot be brought which is violating the basic feature of the Constitution of India or the basic structure of the doctrine of India. And wherever the limitation, whatever the limitation and subjects are there for the Parliament, the ordinances will be issued by on those subjects only. For example, the Parliament can make laws on the union list, congruent list and residuary things. So President can issue ordinances on all these things only. Governor, State Legislative Assembly, they can make laws for the state list, congruent list only. So the governor can issue ordinance only for these kinds of things. So whatever the limitation and restriction is there for the Parliament as well as the State Legislative Assembly, that limitations and restrictions will also be there for the bringing out ordinances inside the ordinances by the President or the Governor, right? Another thing which was in news, which you must have heard, that there was a security breach in the Lok Sabha. दो लोग जो थे यूपीएससी एस्पिरेंट्स ही थे, वो लोग घुस गए थे लोकसभा के अंदर, राइट, और प्रोसीडिंग्स को हैम्पर किया था उन्होंने. टोटल मिला के 6 पर्सन्स थे. सो देयर वाज ऑब्वियस सिक्योरिटी ब्रीच इनसाइड द लोकसभा, राइट. So this was in the news. Now let's understand how this, what are the rules for the parliamentary visitors, है ना. तो ये जितने भी मेंबर ऑफ पार्लियामेंट्स होते हैं और मेंबर ऑफ पार्लियामेंट्स के बियॉन्ड जितने भी लोग लोकसभा राज्यसभा के अंदर जाते हैं, सो दे आर कॉल्ड विजिटर्स, है ना. चाहे वो नॉर्मल पर्सन हो, चाहे वो मीडिया के पर्सन हो, राइट. सो दे आर देयर. So in the Lok Sabha, the entry, exit and the removal of the visitors, they are also referred as the strangers. So they are controlled by the rule 386 of the constitution, not constitution, rules of procedure and conduct of business in the Lok Sabha. So there is already a rules of procedure and conduct of business inside the parliament of the Lok Sabha. Similarly, there is rules of procedure and conduct of business for the Rajya Sabha. So any visitors who is visiting the Lok Sabha or the Rajya Sabha, so they will have to follow these rules and regulations, right. So under Article 386 of the Constitution of India, the speaker decides who can visit the public gallery and when. So it is the speaker's power that speaker can decide who will be there in the gallery and who will not. You must have heard also about the secret session. You must also have heard about the secret session, right. secret session में क्या होता है कि जो मेंबर ऑफ पार्लियामेंट होते हैं, मीन्स जो अगर लोकसभा के अंदर है तो जो लोकसभा के मेंबर होंगे सिर्फ और सिर्फ वही लोग रहेंगे हाउस के अंदर, और बाकी लोग जो भी होंगे वो सब उन सबको हटा दिया जाएगा, राइट. तभी जाके सेक्रेट सेशन कराया जाएगा. बहुत बार होता है कि सेक्रेट डिस्कशन किया जाता है, सेक्रेट वोटिंग की जाती है, राइट. सो सेक्रेट सेशन इज बीइंग हेल्ड. सो इट कैन बी डन थ्रू द आर्टिकल 387 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया. इफ द स्पीकर कैन also ask the visitors to leave if needed, है ना, ताकि सेक्रेट सेशन कराया जा सके विद इन द लोकसभा. MP can only get the visitor pass by the people they know well, right. So how will you go to the member of parliament, to the Lok Sabha? If you want to see the proceedings inside the Lok Sabha, how will you go? You will have to take a pass from any member of parliament, from any member of the Lok Sabha, right. And only when you will be getting that pass, you will be allowed to enter into the Lok Sabha. The visitors cards are usually issued to a member for a particular day for a fixed hours. So you will be given the time slot, you will be given a particular day, that on this particular day from this time to this time, from 12 to like 3 p.m. you can go to the see the Lok Sabha proceedings, right. So that is there. The rules do not allow members to press for the entry of their guests prior to the time incidental in the card. So whatever the time period which have been allotted, at that time period only you will be allowed to enter into that house, right, not before that. And once your time is finished, you will have to come out of the house. So that is there. Visitors to the parliament need security clearances for the parliamentarians. So you will have to go through 3 levels of the security clearances, and once those security clearances have been passed, only then you can go to see this. Similar rules are there also for the Rajya Sabha. So both for the Rajya Sabha as well as for the Lok Sabha, there is rules of procedure and the conduct of business, and as per that, a visitors are allowed to sit inside the house to see the proceedings of the Lok Sabha or the Rajya Sabha, right. But there are lots of security, and this security breach has taken place when such news came. ठीक है, I hope that is clear to you. Now 75 year of the constitution, 75 year बीत गया है ना. So A special session of the parliament agenda indicates that it may be used to shift the proceedings. So the special session to debate parliament 75 years journey. तो पार्लियामेंट का 75 ईयर जर्नी को डिबेट करने के लिए ये सारा सेशन कंडक्ट कराया गया था. Right, a special session was being held. New parliament, you know that new parliament has been made, and Lok Sabha, Rajya Sabha both has been shifted to the new parliament. Right, इसके लिए भी स्पेशल सेशन हुआ था. तो ये जो स्पेशल सेशन वगैरह होता है, that can only take place if proper secretariat is there. आप इवन डिस्ट्रिक्ट के अंदर आप लोग देखोगे कि जहां पर डिस्ट्रिक्ट मजिस्ट्रेट बैठता है, डिस्ट्रिक्ट कलेक्टर बैठते हैं, राइट, तो वो क्या होता है, सेक्रेटारिएट में बैठते हैं. सेक्रेटारिएट क्या होता है, जहां पे स्टाफ होते हैं बहुत सारे, टू हेल्प द डिस्ट्रिक्ट कलेक्टर्स, सो दैट द ऑफिस ऑफ डिस्ट्रिक्ट कलेक्टर्स should function properly. Right. Similarly, in the parliament, only member of parliament is not enough. The member of parliament, they themselves will not be typing all the bills, right, which is going to be discussed. They themselves will not be typing all the notices, right. So lots of staff are actually required in the proper functioning of a house. So both the houses has a separate secretariat. So a secretariat of the parliament is there. So and this provisions for the secretariat is there inside the Constitution of India itself. So Article 98 of the Constitution of India, it says that each house of the parliament shall have a separate secretariat staff. Article 187 of the Constitution of India makes similar provisions for the secretariat of the state legislatures. Recruitment and the condition of service, the governed by the Lok Sabha Secretariat recruitment and the condition of service rules 1955. So there is different rules, procedures for the Lok Sabha, different rules and procedures for the Rajya Sabha, means how those staffs in the secretariat will be recruited. So for that rules and regulation is there. The leader, in case of Lok Sabha it is a speaker, in case of Rajya Sabha it is chairman. The speaker and the chairman of each house of the parliament can create new staff position within the own office, right. So if new recruitment is required, if some new offices is required, if some new post is required, who can create this? For the Rajya Sabha the chairman can create this, for the Lok Sabha the speaker can create this. The secretary general of both the houses means head of the secretariat, that will be the secretary general. So secretary general of both the houses holds the rank equivalent to the cabinet secretary, and cabinet secretary, you know that it is the highest position an IAS officer can reach up to, right, cabinet secretary level. So that is there. th anniversary of 73rd and 74th constitutional amendment, right. 1992 का एक्ट है, लेकिन इम्प्लीमेंट हुआ था 1993 से. तो 2023 में 30 इयर्स हो गए इनके. So how in the 30 years this Panchayati Raj system and the urban local governments, how they are functioning, right. So that has been on the debate and that has been in the news. So there are high chances that the questions may come from the local governance, Panchayati Raj system or the local governance in upcoming prelims exam. So if you see, then the 73rd Constitutional Amendment Act, Balwant Rai Mehta Committee, on the recommendation of Balwant Rai Mehta Committee, it is assumed that this 73rd Constitutional Amendment Act has been brought. Several more committee has been there, right? The LM Singhvi committee and more Gadgil committee. So that has also been there, but more important was the Balwant Rai Mehta committee, because this was the first committee which has recommended for the Panchayati Raj system to be implemented. So through the 73rd Constitutional Amendment Act, a new part was added, that was part 9 of the Constitution of India. Several articles was added, that was article 243 to 243O was added. 11th schedule of the Constitution was added. Within the 11th schedule, 29 items has been put up, that on these 29 items the Panchayati Raj government will be able to they will have the power to function on these 29 items. Similarly, there are 74th Constitutional Amendment Act. This is for the urban local governance. A new part, that is part 9A of the Constitution, was added. Several articles like the article 243P to article 243ZG was added inside the Constitution of India. The schedule, that is 12th schedule of the Constitution was added, and in the 12th schedule 18 items has been provided, right? So that is there. In the article 243I, there is a provision of setting up the State Finance Commission for every 5 years. As you know that the Election Commission of India is there. Election Commission of India, it is there to conduct the election for the President, Vice President, Parliament and the State Legislative Assembly. The Election Commission of India does not conduct election for the Panchayati Raj system or the urban local governance. So for that, for the conducting the election of the Panchayati Raj system and the urban local governance, State Election Commission is there, right? So that is there. Another thing is that reservation provisions has been there under the 73rd and 74th Constitutional Amendment Act. Now reservation are there for the several kinds. For example, SC/ST reservation. SC/ST reservation in any panchayat or any urban local governance, urban local area, is on the basis of proportion of population. On the basis of proportion of population, right? SC/ST reservation is there. But for the women, there is minimum 1/3. Minimum 1/3 reservation is there, means minimum 1/3 seats will be reserved for the women. There are some states like the Bihar where there is 50% reservation for the women in the Panchayati Raj system. So this reservation system is there for the SC/ST and the women, right? For the women, even at the chairman level there is reservation. Then there is state election commission, we have already talked about, but we have not talked about this State Finance Commission. So just like the Finance Commission of India, which is there inside the article 280 of the Constitution of India, right? The Finance Commission of India, it recommends to the central government that how much funds should be allocated to the from the center to the states, right? So that is there. Similarly, State Finance Commission will be set up, and this will be recommending, State Finance Commission will be recommending to the state government that how much funds should be allocated to the Panchayati Raj system or to the urban local governance from the consolidated fund of the state, right? Even the Finance Commission, Central Finance Commission, they have the power that some funds from the central funds can be allocated to the Panchayati Raj system also, right? So there will be dedicated State Finance Commission which have the similar power, which have the similar role, just like the Finance Commission of India, to recommend the state that how much money should be transferred from the state to the panchayats or the urban local governance. And one very important point you should remember that ऐसे तो पंचायत election held for 5 years, for the tenure of 5 years. लेकिन let's suppose after 3 years the government collapses, right? So the new election which has to be held for the panchayats, that will be held only for the remaining period, right? So मान लो 3 years के बाद ये टूट गया, तो इसके बाद सिर्फ 2 years के लिए नया पंचायत बनेगा, और जब 2 year खत्म हो जाएगा तो वापस से 5 साल के लिए बनेगा, right? So that is there, means if the midterm में इलेक्शन कंडक्ट करवाना पड़ जाता है, तो इन दैट केस इट विल बी देयर फॉर द रिमेनिंग पीरियड ओनली. और यही चीज अभी भी डिस्कशन में चल रहा है. जैसे साइमल्टेनियस इलेक्शन, वन नेशन वन इलेक्शन की बहुत ज्यादा बात चल रही है, न्यूज में बहुत ज्यादा है. साइमल्टेनियस इलेक्शन कैसे कंडक्ट करवाया जा सकता है? अगर मान लो कि कोई गवर्नमेंट गिर गई बीच में, लोकसभा की या फिर स्टेट लेजिस्लेटिव असेंबली का, तो उसको रिमेनिंग वहां पे इलेक्शन कंडक्ट करवाना पड़ेगा, और इलेक्शन कंडक्ट करवाना पड़ेगा तो उसको रिमेनिंग टाइम पीरियड के लिए ही करवाया जाएगा, राइट? तभी तो साइमल्टेनियस इलेक्शन जो है वो पॉसिबल हो पाएगा बार बार. तो पंचायत में ऑलरेडी ये चीज हो रहा है. Another thing which was in news was Panchayat Extension to Scheduled Areas Act. Right. So this was in news because in Odisha there has not been rules framed since last 27 years for the Panchayat Extension of the Scheduled Areas. Right. इसलिए ये न्यूज में था. बट होता क्या है ये पीसा एक्ट, पंचायत एक्सटेंशन टू द शेड्यूल्ड एरिया एक्ट? तो एक्चुअली जिस टाइम पे पंचायती राज सिस्टम आया था, पीआरआई पंचायती राज इंस्टीट्यूशन जिस टाइम पे आया था 1993 से इंप्लीमेंट हुआ था. ड्यूरिंग दैट पीरियड, ड्यूरिंग दैट टाइम व्हाट वाज हैपनिंग, the PRI was not implemented in 5th schedule of the Constitution of India. It was not implemented in the 5th schedule of the Constitution of India. 5th schedule, you know that what is this 5th schedule? It is the tribal area in some 10 states. Right, ट्राइबल एरिया इन सम 10 states it has been there. तो वहां पे इंप्लीमेंट नहीं हुआ, बट विद इन 3-4 years another one committee was there, दिलीप सिंह भूरिया committee. This Bhuria committee recommended that the panchayat should be extended even to the panchayati raj should be extended even to the 5th schedule of the Constitution of India, and therefore these provisions came, that is PESA Act came only in 1996 after the recommendation of Bhuria committee. Only after 3 years of the implementation of Panchayati Raj system, that 5th schedule, in the 5th schedule also panchayats should be included, and therefore this act has been brought, that is Panchayat Extension to Scheduled Areas Act. Means panchayat is getting extended to what? Scheduled area. Scheduled area is what? 5th schedule, right? So on the recommendation of the Dilip Singh Bhuria committee, it was there. It is a constitution within the constitution, and Ministry of Panchayati Raj is the nodal agency to implement the Panchayat Extension to the Scheduled Areas Act. 5th schedule वाले area में ये लगता है, and there are lots of powers which is given to the Gram Sabha under the PESA Act. What are those powers? The powers are responsible for the identification of developmental projects, the preparation of the developmental plans and the implementation of these plans, right? Gram Sabha will be consulted if any development projects are to be undertaken in the scheduled area. अगर scheduled area के अंदर कोई developmental projects लाना है तो पहले ग्राम सभा से परमिशन लेना पड़ेगा, उनसे कंसल्ट लेना पड़ेगा, राइट. ग्राम सभा टू प्रिजर्व द इंडिजिनियस ट्रेडिशन, बिलीफ एंड कल्चर, राइट. इट इज योर रेस्पॉन्सिबिलिटी बिकॉज ये क्या है, ट्राइबल पीपल्स हैं. फिफ्थ शेड्यूल एरिया इज फॉर व्हाट, ट्राइबल पीपल. प्लीज रिमेंबर दिस, दे आर द ST people only, they are not SC. There are lots of confusion among the students that fifth schedule is for the SC and sixth schedule for the ST. No, both fifth schedule and the sixth schedule is there for the ST population only, right. So Gram Sabha to resolve the local disputes also. Gram Sabha will also look after the management and the protection of the common properties based on their traditional system, and the administration must be consult the Gram Sabha for land acquisition. If any kind of land acquisition has to be taken place within the scheduled area of this PESA, then Gram Sabha will be consulted. Gram Sabha holds the right to control the distillation, prohibition and manufacturing of the intoxication and liquors. So if any such kinds of things which will be held or the conducted inside the scheduled area, right. So Gram Sabha will be consulted, and their power is immense in this direction, right. This is what ensuring the local governance, right. Another thing which was in news was the panel of vice chairperson. The panel of vice chairperson. Rajya Sabha chairman nominates 4 women parliamentarians to the panel of vice chairperson, and this is happening for the first time. This is happening for the first time in the history of Rajya Sabha. It ensures women equal representation in the panel. Means if 4 women has been made, then there must have been 4 men also. Then only there will be equal representation in the panel, right. So in total there has been 8 members, isn't it? Now first understand this. There is a, in case of Rajya Sabha, there is a chairman. Who is this chairman? Vice President, right. He is the Vice President. Another is Vice Chairman, right. And another is panel of Vice Chairperson, right. So first of all, who will be presiding the Rajya Sabha? Chairman will be presiding of the Rajya Sabha. If the chairman is absent, who will be presiding? Vice chairperson, chairman will be presiding the Rajya Sabha. If vice chairman and the chairman both are absent, who will be there? So in the panel of chairperson, the chairperson must have nominated, must have elected, right. Must have nominated 8 to 11 members, and if any of these will be present, in case chairman and the vice chairman is absent, that person will be presiding in the Rajya Sabha, right. Now let's suppose another scenario comes when the chairman is also absent, vice chairman is also absent, and all the members, let's suppose 8 members are there. So all the 8 members of the panel of vice chairperson is also absent. So in this case, who will be presiding over the Rajya Sabha? So whoever member will be present inside the house, so with the voting, they will be deciding that who will preside over the house, right. So first you should understand this. But one thing you must remember, one thing you must remember, that if the post of chairman is vacant, if the post of vice chairman is vacant, in that case, will any person of the panel of the vice chairperson will be presiding? No. There is difference between absence and vacant. Absence means ये सब हैं, आए नहीं आज. Vacant मतलब कोई है ही नहीं, ये सब है ही नहीं. तो जब चेयरमैन ही नहीं है तो ये किसको, जिसको नॉमिनेट किया है उसका क्या वैल्यू है? उसका कोई वैल्यू नहीं है, राइट. तो जिस टाइम पे चेयरमैन एंड द वाइस चेयरमैन का पोस्ट वेकेंट होता है, उस टाइम पे प्रेसिडेंट डिसाइड्स हु विल बी द प्रिजाइडिंग ऑफिसर ऑफ द राज्यसभा. एग्जैक्टली सिमिलर सिनेरियो इज देयर फॉर द लोकसभा ऑल्सो. देयर चेयरमैन को कहते हैं क्या? स्पीकर. वाइस चेयरमैन को क्या कहते हैं? डिप्टी स्पीकर. एंड पैनल ऑफ चेयरमैन वाइस चेयरपर्सन को क्या कहते हैं? पैनल ऑफ डिप्टी स्पीकर. सेम सिनेरियो होता है, एग्जैक्टली सेम सिनेरियो होता है लोकसभा के केस में भी, राइट. सो द चेयरमैन नॉमिनेट्स द पैनल ऑफ वाइस चेयरपर्सन. They preside from the absence of the chairman and the deputy chairman, but when the seat of the chairman or the deputy chairman is vacant, they cannot preside over the house. Actually, president appoints the member in the house in that case. ठीक है, ये समझ में आया? Another thing which was in news was special session of parliament. No question our private member business during September 18 to 22 special session of parliament. Parliamentary Affair Minister Prahlad Joshi announced a special session of the parliament for 5 days but keep the agenda for it under wrap. So this was in the news. क्योंकि स्पेशल सेशन ऑफ द पार्लियामेंट कंडक्ट कराया जाता है time and again whenever it is required, then a special session of the parliament can be conducted. Who will be the authority who can conduct this special session of the parliament? So whether it is mentioned in the Constitution of India, it is not mentioned in the Constitution of India. Constitution of India के अंदर सेशन की बात की गई है, and that is only it is talking about कि there will be will not be more than 6 month gap between 2 session of the parliament, right. इतना ही बात किया गया है. बट इन जनरल आप अगर देखोगे तो 3 सेशन होता है पार्लियामेंट के अंदर, दैट इज बजट सेशन एंड मॉनसून सेशन एंड द विंटर सेशन, राइट. सो दैट इज देयर. Article 85 of the Constitution of India, it mandates that the Parliament should meet at least twice a year. तो यहीं से 6 month वाला जो सिनेरियो बन जाता है. The Cabinet Committee on the Parliamentary Affairs, it determines the date and duration of the parliamentary session. So it is being decided by whom? There is a Cabinet Committee on the Parliamentary Affairs, and that will be deciding when will be the session will be conducted, right. And then this thing is being communicated to the what? President of India. The President of India then summon the session, है ना. So the President then summon the MPs for the session, है ना. Summoning and prorogue, summon and prorogue can be done by the President of India, and adjournment sine die can be done by the presiding officer of the house. लोकसभा के केस में स्पीकर, राज्यसभा के केस में चेयरमैन. ठीक है, ये समझ में आ रहा है. तो स्पेशल सेशन ऑफ द पार्लियामेंट कैन बी कंडक्टेड, लेकिन इसके लिए कैबिनेट कमेटी ऑन द पार्लियामेंट्री अफेयर्स को डिसाइड करना पड़ता है कि स्पेशल सेशन कंडक्ट कराना है, कितने दिन का कराना है, और इसके बाद ये कम्युनिकेट कर देते हैं प्रेसिडेंट को. प्रेसिडेंट जो है वो समन कर देंगे हाउस को, और वहां पे स्पेशल सेशन ऑफ द पार्लियामेंट कैन बी कंडक्टेड. Another thing which was in news was subordinate legislation or the delegated legislation. The rules made by the center, states cannot exceed powers granted by the parent statutes. The Supreme Court ruling. होता क्या है ये सबऑर्डिनेट लेजिस्लेशन और द डेलीगेटेड लेजिस्लेशन? न्यूज में तो था ये केरला इलेक्ट्रिसिटी बोर्ड से रिलेटेड जो था वो सुप्रीम कोर्ट से था कि द सुप्रीम कोर्ट रूलिंग ऑन द केरला इलेक्ट्रिसिटी बोर्ड्स अपील होल्ड दैट द डेलीगेटेड लेजिस्लेशन such as the rules and regulation must not supplant, exceed or be in compliance with the law they derive power from. तो जो पावर दिया गया है थ्रू एनी लॉ और एक्ट उसके अंदर ही रूल्स बनाना है. रूल्स बना सकते हैं थ्रू द डेलीगेटेड लेजिस्लेशन. रूल्स बनाया जा सकता है फॉर द थ्रू द डेलीगेटेड लेजिस्लेशन. सबऑर्डिनेट लेजिस्लेशन से थ्रू रूल्स बनाया जा सकता है, लेकिन उस लॉ के अंदर ही जितना पावर अलाउ किया गया है उस पावर को होल्ड करते ही लॉ रूल्स बनाया जा सकता है. सो व्हाट इज दिस सबऑर्डिनेट लेजिस्लेशन? Subordinate legislation is a legislation made by an authority subordinate to the legislature. The committee on the subordinate legislation, ये जो है राज्यसभा के अंदर, ऐसे ही लोकसभा के अंदर भी होता है. So they are constituted under the rule 204 of the rules of the procedure of conduct of business in the council of the states. और ये क्या कमिटी जो होंगे वो क्या डिसाइड करेंगे? वो डिसाइड करेंगे कि they scrutinizes and report to the house whether the power of subordinate legislation delegated by the parliament has been properly exercised or not. ठीक है, देखो कोई भी एक्ट बनता है, ठीक है, सो द पार्लियामेंटेरियंस के पास ज्यादा टाइम है नहीं उस एक्ट को डिस्कस करने का, उसके एक एक रूल्स रेगुलेशंस को बनाने का. तो जो मोटा मोटा चीज होता है उस एक्ट के अंदर बन जाता है, राइट. सो द लेजिस्लेचर्स most of the times what happens, legislature makes act, but इस act का rules will be made by the executive, and this is what, this is subordinate legislation. For example, Citizenship Amendment Act, CA 2019. This act came in 2019 made by the parliament, लेकिन इसका रूल्स जो बना है वो बना है 2024 में by the concerned ministers, right. So this is what, this is subordinate legislation. I hope this is clear to you. And the last topic for today is, you must have read this, one nation one election. On yes side are BJP allies or friendly parties, so such kinds of things are there. One nation one election or the simultaneous election, if it has to be held, right, it cannot be held without cooperative federalism. Consensus has to be built among smaller parties and the larger parties that yes, we need one nation one election. Voters awareness is very much required, right. So what is required? Cooperative federalism is required. The collaboration, the cooperation between the center and the states, because at the states level small parties functions at the local level, right. At the central level large party makes the government. So there is need to have collaboration. Cooperative federalism is required. So how this cooperative federalism happens in the country? So if you see what are the provisions, then you will find that the 7th schedule of the constitution 7th schedule of the Constitution, it talks about the union list, state list, congruent list, and on the union list who can make law, union government, state list में who can make law, state government, and on the congruent list who can make law, center as well as the state. And in case of residuary thing, who can make law? Union, right? So what is this? This is the provisions for cooperative federalism. Then all India services under the Article 312. There are 3 all India services: IAS, IPS, and Indian Forest Services. So for these kinds of services, cadre allocation is there. When you will be clearing your prelims, you will have to fill your detailed application form, DAF, and in the DAF you will be asked cadre for IAS, cadre for IPS. Similarly, those who are preparing for the forest services, they are being asked cadre for the forest services. These are the all India services what they have been recruited by the central government, but they will be allocated cadre, that is state cadre, and there they will have to work for 20-30 years, right? So that will be there, and under Article 312 of the Constitution. So what is this? This is called cooperation between the center and the states. Then Article 261 of the Constitution of India, it provides that full faith and credit shall be given throughout the territory of India to all the public records, public acts, judicial proceedings of the Union and every states. So whatever the judicial proceedings will be there by the Supreme Court, by different courts, like for example Bihar High Court, for example Madhya Pradesh High Court, right? So such there will be values and respect for those proceedings, right? Similarly, whatever the orders, public orders, government orders will be given by the Bihar government or the Rajasthan government or the Tamil Nadu governments, so they will be respected, right? So that will be there. Article 262 of the Constitution, it allows the Parliament to adjudicate interstate water disputes. So interstate, if there is any interstate water disputes, that has to be adjudicated. Because of this Interstate Water Dispute Acts 1956 came, River Board Act 1956 came, right? So that to educate the water disputes arising between different states in our country, right? So that is there. Then Article 263 of the Constitution of India. Article 263 of the Constitution of India, it talks about interstate council. So to have the collaboration and coordination among the different states. In 1990, interstate council was established, right? In this interstate councils, Prime Minister, Chief Minister of all the states, other ministers will be there, and they will be collaborating and cooperating. They will be having several kinds of meetings, right, to find a common interest between the center and the states. Though not much successful, but for the cooperative federalism you can give such examples. Article 279A of the Constitution of India, GST council has been made, right? One nation, one tax is goods and service tax. Through the 101st Constitutional Amendment Act, GST has been implemented, right? So GST council has been made. This GST council will decide upon the several things. What should be the on which items how much tax should be applied, what should be the flow rate for different types of items, right? So several other things will be decided by the GST council. This is also a cooperative federalism. Article 280 of the Constitution, it talks about the Finance Commission. Finance Commission gives recommendation. So right now the 16th Finance Commission is now coming up. 15th Finance Commission has given the recommendation that 41% of the consolidated fund of India, that should be allocated to the states, 1% should be allocated to the J&K and the Ladakh, and rest 58% should be kept by the center, right? So such kinds of provisions, this is also important for the cooperative federalism. Zonal councils has been formed. Zonal councils has been formed through the State Reorganization Act 1956. Right. Similarly, for the northeastern region, northeastern zonal council 1971 came. Right. And for this zonal council has been formed. Means whole India was divided into different zones: north, south, east, west, central, and the northeastern states. And within that zone, there will be collaboration and cooperation between the states and the center. Right. So all these things you can give examples. So this was all in our first class. In the next class, we will be trying to complete the all current affairs. So by now you must have understood that how you have to read the current affairs. There will be some issue in the news. Regarding that issue, some concept you will have to prepare for your prelims point of view. For example, if any ordinance has come up by the president, right? So not necessarily that UPSC prelims, in that UPSC prelims, that ordinance will be asked. Okay, what are the key provisions of that ordinance? But the conceptual, you should have the conceptual clarity of that how ordinance is being promulgated, in what scenario ordinance is being promulgated, right? So such things is very important. So we have seen the issues as well as the concepts around that issue, right? So this is all in today's class. We will be continuing this series, right? In next class, we will be coming up with the further discussion. Thank you very much.